Hello and good morning. My name's Francine Harrigan. I'm with the United Nations Department of Public Information. We're very pleased to have you join us today for the briefings on unilateral coercive measures and a democratic and equitable international order. Today, to share with us their key findings, I'm pleased to welcome Mr. Alfred Maurice de Zayas in the middle, independent expert on the promotion of a democratic and equitable international order. And to my immediate left, Mr. Idriss Jazairy, Special Rapporteur on the negative impact of unilateral coercive measures. Both speakers are part of the special procedures of the Human Rights Council, which are independent fact-finding and monitoring mechanisms that address either specific country situations or thematic issues. Special procedures experts work on a voluntary basis. They are not UN staff and do not receive a salary for their work. They're independent from any government or organization, serve in their individual capacity, and express their individual opinions. With that, I pass the floor to Mr. de Zayas. Thank you.
So good morning, everybody. Thank you very much. I don't see Matthew in his usual seat. I hope he comes. I do, because I always like his questions. As the case may be, this was my last report to the General Assembly. I presented 6 reports to the Human Rights Council, 6 reports to the GA on 12 different topics. And now I've been asked by the Human Rights Council to do a wrap-up report, a final report for the March 2018 session. That's the 37th session of the Council. And then my mandate ends, and there will be a successor. And let us hope that he will take the flambeau and go further in trying to promote an international order that is more in keeping with General Assembly Resolution 2625, the Friendly Relations Resolution, and also more in keeping with the General Assembly Resolution on a new international economic order. As the case may be, the bottom line of my report, I tried to be fair. I tried to see where there's been progress in the policies of the World Bank and of the IMF. What they have done, like the World Bank has an inspection panel, it has a compliance advisor ombudsman, and the IMF has an independent evaluation unit. And they have been looking more and more into the human rights, health, environmental impacts of their work. And problem with the IMF, because my report here focused only on the IMF, is their loan conditionalities. And in the past, they had this policy of structural adjustment. And now, over the last 30 years, we have had plenty of evidence how much these structural adjustment policies have failed and how many human rights violations they have engendered, especially for the most vulnerable. So I have proposed to do away with this kind of structural adjustment that is imposed on countries and that completely sabotages the policy space of governments. And of course, the obligation of governments to fulfill their, hi Matthew, to fulfill, is not Matthew, to fulfill their human rights obligations under the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights. Now, there are classical conditionalities that have been applied to Greece, have been applied to Argentina, have been applied to Tunisia, etc., are privatization and deregulation of financial and other markets, and so-called austerity measures. Austerity measures can mean, firing 10,000 civil servants, and that creates a huge problem of unemployment, and that also creates instability in the country itself. I think that if you want creditors to get their money back, you have to kickstart the economy. You have to make sure that there is consumption. And if you throw people on the street because, you know, it costs money to pay civil servants, then those people have no possibility to consume. And it actually has backfired, these old conditionalities. And I propose different conditionalities, and those are, one, a moratorium on military expenditures other than salaries and pensions, of course, but any procurement, etc., for the duration of a loan. I mean, it's ridiculous that a country like Greece, that is bankrupt, is required by NATO to spend $2 billion or something like that in the military. And it's contra legem. It's ridiculous that this is being imposed by NATO on Greece. I think that one of the conditionalities really has to be, if you give money to a country that is bankrupt, that country cannot waste its natural resources in so-called defense. And that being the case, I propose a system of collective security, that a country in a situation like Greece will be guaranteed by the collective security system without having to spend money for the military. So, moratorium on expenses, military expenses. Number two, tax policy. You have to make sure that tax havens are outlawed. You have to make sure that persons who have monies offshore bring them in, like France has done successfully. And if you don't bring your money in, you will be subjected to significant penal sanctions. Another thing is, of course, legislation to curb corruption, bribery, and all of that. I mean, a country needs to get its tax revenue. It needs to get the tax revenue from transnational corporations. So the idea of having profit shifting to secrecy jurisdictions or to jurisdictions where the tax level is much lower must be phased out generally, but more so as a loan conditionality for IMF loans. And I also proposed that which is very well known, has been around for 40 years, which is the Tobin tax, the so-called financial transactions tax. If countries adopt financial transactions tax, they will bring in the revenue that they need to pay back their loans. But if you force the country into an abnormal situation of privatization, deregulation, and austerity measures, that country is never going to get out of its situation. And I do hope that the IMF will follow its own experts. I participated in a number of side events at the annual meeting of the IMF and the World Bank in Washington. That was in April 2017. Had the opportunity of speaking with top economists and lawyers of both organizations. And I find that many of them actually see the situation more or less like I see it. And they find that neoliberalism, this philosophy that has actually governed the IMF since the beginning, has in many, many areas failed to bring the growth that they were supposed to deliver, and they have engendered human rights violations. So there is already an awareness in the IMF that major reforms are necessary. And that, of course, has to be agreed by the states. And I have had the opportunity of speaking with many ambassadors and many states and say, you are members of the IMF, do something. You are obliged under the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights to make sure that your human rights commitments are not hindered by other commitments in the IMF. And if there is a conflict between, on the one side, economic considerations and on the other side, human rights considerations, I think we all agree that human rights considerations must prevail. So that was basically the core of my message to the General Assembly on Tuesday. And I will continue this week in bilaterals with a number of delegations. And I will incorporate all of that into my final report to the Human Rights Council next March 2018. Thank you.
Thank you. I'll now hand the floor to Mr. Jazairy. Jazairy, sorry.
Thank you, and welcome to all. My report to the General Assembly this year had three main components. The first was to follow up on some proposals that I had made already last year with respect to the establishment of a register of all unilateral coercive measures that are currently in force. At present, you have practically one-third of humanity that lives in countries that are the subject of some kind of unilateral coercive measures. And it seems that it's getting a process that is spreading out of control, and that at least there should be transparency, whilst it's recognized that multilateral sanctions taken by the Security Council are within the provisions of Chapter 7 of the Charter. These unilateral coercive measures have a degree of legitimacy which is actually challenged by the overwhelming majority of UN member states. So I suggested and I submitted this proposal to the Human Rights Council that welcomed it, that some such register should be established at the UN in New York in order to provide transparency. It would also be helpful for the Security Council to know what unilateral coercive measures are being implemented at a time when the Security Council is looking at the possibility of sanctions under Chapter 7 in order to avoid a contradiction between the Security Council sanctions and the ones that are being imposed by individual states. And it would also be helpful for civil society. If you have noticed, civil society nowadays is not very articulate about the adverse human rights impact of these sanctions, despite the fact that the Covenant on Economic, Social, and Cultural Rights says that the population of a country should not be made to pay for any insufficiencies or shortcomings by their leadership. And yet, this is the case at present. So I feel that there is a need for civil society organizations worldwide to wake up to this fact, and perhaps the availability of the information in the register would be helpful. And finally, for the business sector. At present, people don't exactly know what the impact of these unilateral coercive measures, abbreviated UCMs, what they can still do in terms of business with a country. And they're scared stiff that they might be made to pay huge fines for doing business where one country considers that they should not be doing business. So there is a phenomenon which has devastating consequences, which is the phenomenon of overcompliance. For these three reasons, a register is something that I hope the General Assembly will support at this meeting and ask possibly the Human Rights Council to come up with a proposal in this regard. The second issue is the one of unilateral coercive measures and the rule of law. There is a difference in perceptions between some industrialized countries and the rest of the world as to the legality of these unilateral coercive measures. I don't want to get into that. But I say at least pending the ultimate elimination of unilateral coercive measures, if they are found finally to be illegal by international law standards, at least to agree now in the transitional period as to how to limit the damage of these measures with respect to the vulnerable group in a particular country. As I say, these innocent people should not be made to pay for whatever mistakes their leadership may commit. So, therefore, I suggest that we pick from international law, as it exists today, all the elements that could fit into a declaration of the short to medium term and the longer term of the do's and don'ts of such measures, which at present are like a jungle where nobody has any right of regard. So that's a second subject. And I think it's realistic that we should elaborate. But everybody says they support the rule of law. So this is UCMs and the rule of law. Anything that conforms with the rule of law in terms of proportionality, in terms of human rights impact, etc., should be put in a declaration adopted by the General Assembly. And I hope that the General Assembly will adopt that. I was also asked to look at the possibility of setting up a compensation system for people that were adversely affected by these measures. And that is an issue on which I have also made some proposals. The second subject that I raised during this in my report is a very topical subject. It is the subject of extraterritoriality. This problem of extraterritoriality has two aspects to it. The first aspect is the legitimacy of a state targeting another state with sanctions and expecting that their allies or others also apply the same sanctions to that particular state, even if their own democratic processes have not adopted, like the initiating state, a law to target those particular countries. So it creates it raises a point of law, and I think there should be no ambiguity that while a state is free to adopt legislation to apply embargo on another state if it so wishes, it is difficult for it to expect that other states that have not taken such a decision to sanction a particular targeted state should also comply. So this is the first aspect. And I think that the issue is coming to a fore today. When you look at the commitments taken by Western Europe towards Russia, for instance, you see that there's a new batch of sanctions which is being applied now by a sanctioning state against Russia, which would lead those Western European countries that have heavily invested in joint projects with Russia, just to mention the pipeline from Russia to Germany, that they would therefore lose their money. Who deals with the consequences of this situation? Take another case. Iran, we'd moved on an agreement with Iran to to solve the nuclear disagreement, to reach an agreement on the nuclear non-proliferation, and with, as a counterpart, the lifting of sanctions. I understand that one state now intends to apply unilaterally some new sanctions to Iran, whilst the conditions to trigger the sanctions have not been fulfilled. So the question arises, other states, if they are expected in the name of extraterritoriality to apply the same sanctions to Iran that they do not agree to in the first place, it would mean that all the business that's developing now between, say, the EU and Iran in the sale of Airbus and all that would have to be canceled suddenly. Mm-hmm. Is this going to make people protect the right to development of communities in Western Europe? Take another case, hypothetical. If tomorrow they are, in addition to the Security Council sanctions concerning the DPRK, the Security Council sanctions are unexceptionable. But if a state decides to apply additional sanctions not agreed upon by the Security Council and expects countries in the region also to apply them, I would wonder whether such country would accept to extend sanctions just that are initiated in terms of domestic law by one country to one of their neighboring countries, to the neighboring countries of the country that would be asked to apply the extraterritorial principle. So, my conclusion is that whilst when you apply sanctions to developing countries directly, that can be handled, exercises pressure, whatever. But when you get involved in this extraterritorial situation involving other developed countries, then you could really trigger a major trade war. And for what purpose? If you look at the sanctions applied between 2013 and 2016 to Russia by a number of Western countries, I have made a visit to Russia and to the EU, and I have found out that the sanctions applied by the sanctioning countries, which cost about 50 billion in lost income to Russia, cost the European farmers $100 billion. They lost more through the reciprocation by Russia of the sanctions than what they inflicted as damages to Russia itself. So I ask myself, if it's a win-lose situation, okay. If it's a win-win situation, so much the better. But if it's a lose-lose situation, it doesn't make a lot of sense. Now, I don't take a position on the merits of a case, but I just say that there is, whatever the situation is, extraterritoriality is a major challenge at present, and it applies in this context, but there's also another aspect to extraterritoriality, the second. This second aspect is that if a country applies measures which have damaging effects on a particular group, for instance, in the case of the Sudan in the past, I visited Sudan, and people could not get insulin anymore for people suffering from diabetes because the company producing insulin in Denmark was bought over by a US company. So because of that financial transaction, people were dying in Sudan from diabetes like they were not dying anywhere else in the world. So the question is, extraterritoriality means that the country applying sanctions has a responsibility beyond its jurisdiction for the consequences of its acts. Because if a country is entitled, has an obligation to preserve the human rights of its own people, it has also an even greater obligation to preserve or not to undermine the human rights of another people. So this is why I say that sanctions are a very blunt instrument. And that my third point, in summary, if I could, it's a good news. We have, through efforts, my mandate and the international independent expert on the Sudan have joined forces in trying to bring together through quiet diplomacy the opposing views of the US and Sudan to try to bring them closer together. We have exercised pressure on the Sudanese as well as on the US. We have not said the good guys are the Sudanese and the US are the bad guys. We're not passing a judgment, but we're saying people are suffering in Sudan like nowhere else perhaps in the world. So we were successful in getting through mutual accommodation over 16 months of quiet diplomacy, a meeting together of the Sudan and the United States. So I took this opportunity when I addressed the General Assembly yesterday to express to the United States and to the Sudan, but more especially to the United States, our tremendous gratitude and appreciation for this process, which started under the Obama administration, but it wasn't quite completed, and the transition team asked for a period for them to review progress on human rights in the Sudan. But I want to pay tribute to the fact that the Trump administration did not use this as a party issue between Democrats and Republicans, and they decided finally to raise these sanctions as from the 12th of October 2017. This is the way that my mandate, I think, should work, to get people to talk, to help them find mutual accommodation for the greatest good of world humanity in general. Thank you.
Thank you both. We have time for one or two quick questions as we're actually out of time, but please go ahead.
Thank you very much for the opportunity. Waldo, Prensa Latina. In less than 2 weeks, the GA will vote on a new draft resolution, the 26th, on the issue of the embargo or blockade against Cuba. What is your position and comment on that? And my second question, in the context of the implementation of the 2030 agenda, do you believe that the unilateral sanctions represent a threat to the goal of let no one behind? Thank you very much.
Whatever the reasons are for the sanctions, we had initiated a process with the Obama administration to try to lift the sanction as progress was continuing. I think if you have sanctions and you don't talk to one another, then it's a waste of time. But the least you could do is to ensure that as you apply sanctions, you also discuss and negotiate so that you move. And in the case of Cuba, having them applied for half a century and still going back to them now is not entirely logical. When you take a policy orientation, there must be some degree of consistency. And after all, this is gambling with people's lives. So I think that I hope that a process of negotiation can get started so that you can finally find a better solution. These measures, sanctions in general, it's like carrying out a delicate operation with a kitchen knife. It's a blunt tool. I know what the objective is, but it very seldom works. Thank you.
Thank you. Mr. Zayas, you had a couple
Just a brief comment that I
question.
fully endorse what my colleague Idriss Jazairy has said, and thank you for the question from Prensa Latina. it's quite clear that unilateral coercive measures are incompatible with international law and are incompatible with a democratic and equitable international order. So in my own reports, I've had to address a number of unilateral coercive measures, and I have said they have to be phased out in the name of the victims. But more than just phasing out unilateral coercive measures, it must be clear, and it has been clear since the report of the United Nations Subcommission on the Promotion and Protection of Human Rights back in the year 2000, that these unilateral coercive measures are incompatible with the obligations of the states under their human rights treaties, and that not only do you want to have compensation for the victims and compensation to those who lose their lives. You mentioned the right to life, Article 6 of the Covenant on Civil and Political Rights. If you cannot get insulin and you die, actually the country that has implemented these unilateral coercive measures has actually killed you, has actually violated Article 6. And I think it's very important that people concretize what it means to apply such sanctions unilaterally and do so much damage, and that there is hitherto total impunity for it.
Thank you. Did I see another question? Otherwise, I think we're actually over time. You can do a very quick one. We're actually already over time. But yeah, a quick one, Matthew. Thank you.
Sure, thanks a lot. I'll do this. Matthew Lee, University Press. Thanks a lot. I know that your report was on the IMF, and I wanted to ask you about it's come up in this room without really any clear answer. Whether the IMF the issue of debt relief, not just of conditionality, but debt relief. After these hurricanes, there was some discussion of islands like Antigua and Barbuda totally destroyed, still paying some $5 million a day in debt. Do you view this as is there a human rights aspect to this? Should the UN system, under some of its basic principles, not be collecting, on this debt while the Secretary General is flying there and saying everything we can do will be done? What's the relationship between the UN and the IMF? And I wondered if you just on sanctions. I know that you often say Security Council sanctions are legitimate. You're about the Security Council sanctions on Eritrea. Many people now question them because they say they were imposed based on supporting al-Shabaab. That's been disavowed by the experts. But now it says if you don't allow us to inspect you, we're going to keep sanctioning you. Do you think is it really your position that all Security Council sanctions are either legitimate or legal, or what do you think of that sanctions regime? Thanks.
Thank you. If we can have very concise responses.
The IMF, also the World Bank, both have association agreements with the United Nations. So they are members of the United Nations family. They're not subordinated to the General Assembly or to ECOSOC or to UNCTAD. And there is a tendency to work closer together. There's a greater cooperation between the UNCTAD, say, and the IMF. I do believe that debt relief has an enormous human rights component. I think that many at the IMF recognize that, and I have a feeling that Christine Lagarde is listening. And I think that I tend to be optimistic that through their independent evaluation office and through their own formidable experts in international law and in economics, that they will move closer to also advancing the purposes and principles of the United Nations, and not just the idea of greater growth or greater gross domestic product or what have you. Thank you.
Thank you. And on the second question?
On the question of the legitimacy or legality of Security Council sanctions, the European Court of Justice declared in one particular case, a famous case, the Qadi case, I think it was, that the sanctions were not legitimate. So my concern is that my remit is to deal with unilateral coercive measures. I think the Security Council has been active, and I have interacted with the Security Council staff to try to remedy some of the shortcomings of the sanctions taken by the Security Council, moving from comprehensive sanctions to so-called smart sanctions, trying to focus on individual sanctions rather than collective sanctions. And they are having even an ombudsperson in certain cases to be able to challenge this process. We don't have this for the unilateral coercive measures, and I think that if we could move in that direction, it would be helpful. But my remit is clearly defined to address the issue of unilateral coercive measures. Thank you.
Mr. Zayas, you had a quick comment on sanctions?
Not on sanctions. I just want to say, since this is my last appearance before you, the shock doctrine, published 10 years ago, diagnosis correct, implementable recommendations correct, no follow-up. Everything that Naomi Klein says in this book, I reflect in my own report this year, and I would like to see progress in this field. Second, I have written a lot on the human right to peace. And back in 1933, the League of Nations asked Albert Einstein the key question, why war? I can only recommend everyone to read this exchange of letters between Albert Einstein and Sigmund Freud, 1933, it says it all. Thank you.
Thank you so much, and thanks again to our speakers and for all of you for joining us today. That ends today's press briefing.
Matthew, you came.
I did. I was trying to cover this Africa group thing, not unsuccessfully.
I see you picked up the two.
Yeah, I did.
I
did.
They're quite politically incorrect, but you know I'm politically incorrect. Yeah, there you are, and that's something that Kurt Boyd from